Hey everyone, it's Lawrence Mack here, real estate broker out of Mississauga and Toronto, and founder of Real Estate Rookies. And I'm here today with Bita from Stonegate Properties. How are you doing?
I'm well, Lawrence. How are you doing?
I'm doing great. Today we're going to talk about selling your tenanted property. It's a very important thing here in Ontario because tenants do have a lot of rights. And as a landlord or as a realtor representing the landlord, you want to make sure that you know what you can and can't do and make sure that you're on the right side of the legal equation. So that's why it's important. And the other thing that's why it's important is because realtors can't actually do that much. So just make sure you're not overstepping your bounds. You're not covered by insurance for a lot of things. And so just make sure that you put it in the hands of a professional such as Bita from Stonegate Legal Services. So let's just go into it. The general agenda for today is Bita's just going to talk about the different things that's available for your options when you're trying to sell your tenanted property. And then at the end of the process, you can ask your questions to her. In the middle, if you do have a question and it's like very important, I guess, just put it in the chat. I will be monitoring that. But in general, Bita will just be going through her presentation. So next is Stonegate Legal Services. Great. So if Bita, can you just share out your screen?
Absolutely. There we go. How's that, Lawrence?
Looks great. I'm going to put myself on mute and then you can just talk. If anyone has any questions, again, just put in the chat. If you've registered, then you'll get a copy of this in your email. So you get a copy of this anyway. If you got to leave early, that's not a problem. But again, just leave your questions till the end. So take it away.
Excellent. Thank you so much, Lawrence. Good morning, everyone, and happy Monday. Thank you for taking time out of your day to come and learn about best legal practices in owning and operating rental property. In this presentation, we're going to be talking about listing a tenanted property. For those of you who don't know me, my name is Bita Di Lisi. If you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram. We always tend to provide updates with what's happening in the realm of landlords and tenants. If you have one of these smartphones, you can scan that QR code located at the bottom left of your screen, and you can add us in as an automatic contact to your contact list. If you ever come across any circumstances or if you ever have any questions regarding a landlord and tenancy matter, please feel free to contact us. The best method to contact me is via email because I can respond at any time. If you do contact our office, any of our great fierce team members are here to assist you and answer your questions. So let's get started, everyone. My name is Bita Di Lisi. I will tell you a little bit of background about myself. My path started in real estate in and around 2004, 2005, when I obtained my real estate license. And throughout that path, I started acquiring landlord and investor clients who were often out of province or out of the country. And they purchased small to medium-sized apartment buildings, commercial plazas, but they weren't in the country or in the province to deal with the day-to-day activities. So just like every other realtor, what I did was I volunteered to manage their property. And through that path, me and my husband, Rob, we started a property management company. And through our management company and managing our landlords, our clients' investments, we often attended the landlord and tenant board. And 9 times out of 10, our matters would get dismissed at the board because we were not paralegals or lawyers. So because I love learning so much, I went back to school and I obtained my paralegal license. I obtained my paralegal license so that I can assist my own landlord and investor clients with an added service as a legal representative. And then my business just shifted. And what I mean by that is I wasn't selling real estate anymore. I was being approached by a lot of broker of records, managers, and being asked to train their agents with respect to landlord and tenancy matters because unfortunately, OREA and TREB, they don't have training programs to teach agents how to deal with the landlord and tenancy matters. So Now, all I do is our firm provides support, legal support to realtors and their clients. So for the purpose of this information, everything we discuss is for information only. Nothing is to be taken as legal advice. If I can ask that you hold all questions to the very end, I hope to answer all your questions before we reach the end of the presentation. And if I don't, you can put it in the chat and Lawrence and I will open up the floor to a Q&A at the end. So let's get started, everyone. I mentioned in the previous slide that our firm provides support to agents like yourselves throughout the province of Ontario when you're dealing with landlord and tenant matters. And here are the top 3 questions that we get asked at least daily, at least 1 or 2 of these, if not all 3 daily. From agents. Sometimes the agents call me and say, hey, Bita, can we evict the tenant to sell a property? Or the tenant isn't allowing for showings. Can we kick them out? Or the landlord's lease is coming to an end. Can we give the tenant notice to move out? And the hard answer to all these 3 questions is a hard no. No, you can't evict a tenant to sell a property. No, you can't kick out a tenant because they're not allowing for showings. And no, you can't give a tenant notice to move out because their lease is coming to an end. You see, tenants have security of tenure. This is actually in the Residential Tenancies Act. Security of tenure. What that means is that they are entitled and allowed to continue their tenancy after the initial 1-year lease term comes to an end. Now, instead of having a fixed term tenancy, the relationship changes to a month-to-month tenancy moving forward. You see, a tenancy can only be terminated in 1 of 3 ways. Okay, so number 1, if the tenant decides to leave and gives notice. Number 2, if the landlord and tenant mutually agree to end the tenancy. And number 3, by way of a court or board order. Before we dive into the presentation, I want to talk briefly about guaranteeing vacant possession. A lot of agents don't know that there is no such thing, or there's no such guarantee to providing vacant possession, especially on a tenanted property, because all bets are riding on that tenant for that tenant to move out so that the seller landlord can provide vacant possession. However, I want to point your attention to clause number 2, the completion date clause in the agreement of purchase and sale, because you need to know that a vacant possession clause is already innately built into the agreement of purchase and sale. The second sentence of the completion date clause reads exactly as I have it captured here. Upon completion, vacant possession of the property shall be provided to the buyer unless otherwise provided for in this agreement. So as an agent, as a listing agent, if you fail to put in that the buyer to assume the tenants, then you've agreed to provide vacant possession if your client accepts this offer. And I'll tell you, you can't guarantee vacant possession, but if you do make this mistake, one thing we can guarantee is that your clients will point the finger at you. Okay, and I'll tell you, more often than not, when agents are making this mistake, they end up paying for the legal fees out of their own pocket. So just be mindful of the vacant possession clause that's already innately built in to the agreement of purchase and sale. So let's talk about what happens when a property is sold. So now you're mindful of that. So now anytime you're selling or you've listed and selling a tenanted property, you're going to watch for that clause. Let's talk about what happens when a property is sold. So whether an agent calls me or a landlord calls me and they say, I want to sell my house. What are my options? Okay. And I always give them these 2 options. So here are the 2 options when a property is being listed and sold. Option number 1, we're going to be talking about the N12 notice. What's the N12 notice? The N12 notice is a notice to terminate tenancy for the landlord or new purchaser's own use. This is a screenshot of what the N12 looks like. I'm sorry, it's a little blurry. I want you to have a look at this document and see what it looks like. Okay, you don't have to read it here. I would like you to read it, but you don't have to read it here. This is what the N12 looks like, okay? So like the agreement of purchase and sale, the N12 is an editable document. And what I mean by that is that you can fill in the areas that require you to fill in the tenant's information, the landlord's information, who's going to be moving in, the termination date, and the second page is the signature page, who served the notice, okay, well, where's the notice coming from? Like the agreement of purchase and sale, it has certain requirements, okay? Unlike the agreement of purchase and sale, it has certain consequences. So let's talk about the requirements. And we're going to dissect the N12 because this is something that you need to be informed about. I don't necessarily want you to serve or fill out or send this document to the tenant. What I want you to do is listen to the presentation, take it all in because it's a lot of overwhelming information, and be mindful of how to instruct your clients when they're asking you, what do we do with the tenant? Okay. I'll start off the bat and tell you, please do not get entangled with serving this document, okay, for many reasons. Number one, you're not licensed to do so. Number two, your errors and omissions insurance does not cover you. Number three, you don't know what the requirements or consequences are. And number four, you're not only opening yourself up to liability, you're opening up your brokerage to liability. Okay, so 4 reasons for you not to serve any legal notice, especially the N12. So when is an N12 served? I mentioned that the notice is for the landlord or purchaser's own use. If the landlord is serving the N12 for their own use, it must be for the landlord's own use or their immediate family member, child, parent, caregiver for residential occupation for at least 1 year. Okay. On the flip side, if the purchaser requires the property for their own use, there are certain requirements. Okay, so here are the requirements. Number one, the landlord has signed a firm agreement of purchase and sale. The N12 cannot be served if the offer is a conditional offer. Okay, because as you know, conditions are exit clauses. So again, the N12 can be served if the landlord has signed a firm agreement of purchase and sale. Number two, if the property contains 3 units or less. If it's a 4-plex, 5-plex, 6-plex, 7-plex, the N12 cannot be served. Number three, if the purchaser, their immediate family member, child, parent, or caregiver require the property for residential purposes for at least 1 year. Now, there's a side note here. There's nowhere in the agreement, there's nowhere in the Residential Tenancies Act that says how long a purchaser has to occupy the property. Okay, it doesn't exist in the Residential Tenancies Act. It does say that a landlord must move into the property for at least 1 year, not a purchaser. However, it does say that a purchaser must move into the property for residential occupation for a reasonable amount of time. The reason I put 1 year here for the purchaser as well is because if the act says that the landlord must move in there for 1 year, we know that if the purchaser does the same, they will be safe. Okay, so here's a consequence. Okay, the N12 cannot be served if the landlord is a corporation or for members of the extended family. Okay, here's the consequence. If the landlord is a corporation and they serve the N12, the matter will get dismissed once it goes in front of the board because a corporation cannot personally occupy a property. Let's talk about the good faith aspect, okay? Because the N12 notice must be served in good faith. And good faith is having the genuine intention to occupy the property for residential purposes. Okay, landlords should not serve the N12 if they're experiencing problems with their tenant. What do I mean by that? If the tenant has blocked them on Facebook, if the tenant is not returning their text messages or emails, if the tenant is not answering their phone calls, if the tenant is being disrespectful, if the tenant is not being responsive, the N12 cannot be used as a loophole to end the tenancy. Okay, and the reason why is that If it is, and if the tenant is served the N12 and they move out, or if they act on it, there are very strong, heavy consequences that the landlord is going to undertake if they don't move in, or if they don't do as they stated that they were going to do. The tenant has recourse. And what I mean by that is that they can file a T5 bad faith application against a former landlord within 12 months from the date that they moved out. Guys, this is why it's really, really, really important that you don't serve legal notices, because more and more bad faith applications that are ending up on my desk are including not only the real estate agents, but the brokerages. So please do not serve N12s on behalf of your clients. So one of the questions I'm going to get asked guaranteed is, Bita, how will the tenant know if the notice is served on bad faith? So let's talk about bad faith. I have many landlords who call me and they say, you know what, I've had it with this tenant. I'm just going to serve them notice that I'm going to be acquiring the property, and I'll just leave the property vacant, or I'll stage it and make it look like somebody's living there. Or I will just change my address and my driver's license to make it look like I'm living there. Let's talk about bad faith, okay? Because there's a couple of things that you need to be aware of. The first and foremost is that tenants have access to technology, okay? And with technology being their phones at their fingertip, there's information that they can access rather quickly. Okay, and number two, they have 12 months from the date to move out to gather this information. I'll tell you a story. So I had a client who resided in Nigeria, and she owned a condo on King Street in downtown Toronto. And her daughter was actually attending the University of Ottawa. Her daughter calls the mother one day and says, you know, Mom, I really want to move to the condo in Toronto. I want to experience being independent, living on my own, working downtown. And the mother said, okay, I will serve the notice and have the tenants move out so you can move from Ottawa to Toronto. So that's exactly what she did. Nothing wrong with that, because she can serve the N12 via mail. And we're going to talk about service throughout the upcoming slides. So the mother sent the N12 via mail. The tenants, who were great tenants long-term, I think at the time they were there about 4 years. The tenants found another place because they didn't want to interfere with the landlord's plans, and they moved out. Shortly thereafter, the daughter called the mom and says, Mom, you know, I got accepted to the University of Oxford in the UK, and I really, really want to pursue my education, you know, this prestigious university. So the mother, since she was living out of the country, she contacted her realtor friend who resided here in Toronto to put it on the market. And I think, if I remember correctly, at the time it was listed for about $600 or $700 more than what the tenants were paying. And shortly thereafter, the landlord received a bad faith application claiming $15,000 for damages. Okay, let's talk about the test of bad faith, because adjudicators at the board actually use this three-part test to determine whether or not the N12 was served in bad faith. So number one, they ask, did the tenant rely on the N12 in order to move out of the property? So if the tenants were continuing to live in the property, and if the landlord did not serve the N12, would they have moved out? And in this particular circumstance, yes, the tenants relied on the N12 in order to move out. Number two, is there an advertisement of the rental property? Well, I mentioned that the landlord contacted her realtor friend, and the realtor put the property on the MLS for lease. And you guys are well aware that if anyone has access to one of these smartphones, there are certain apps that you can download that you can access lease listings or sold listings, and you can use this as evidence. So to answer that question, yes, there is an advertisement of the rental property. And here's the trigger question. Did the person who was supposed to move into the rental unit actually move in? That's the trigger question. So the landlord had mentioned that her child was going to be moving in, and unfortunately, her daughter did not move in. And when we attended that hearing, the board ordered the tenant to pay what the board ordered the landlord to pay what the tenant was asking. So guys, please don't serve N12s on behalf of your clients. Refer them out to a legal representative or have them do it themselves. You don't want to get entangled with, hey, Agent Lawrence told me to do this. Okay. And then Lawrence gets dragged into this, all this drama. So please stay away from serving legal documents. What are remedies that the board can order on a bad faith application to the tenant? So here's a list of remedies that a board can order. Number one, a rent abatement. Number two, the difference in rent between the former unit and the new unit times 12 months. Number three, an order to pay a fine into the board, moving costs, any out-of-pocket expenses that the tenant has incurred up to $50,000, any other order that the board finds appropriate. Now, the new Bill 184 that has recently been proclaimed, a section of it that has recently been proclaimed now allows a former tenant to come after a former landlord, not only for the rent differential, but the full amount of rent times 12 months, up to $50,000. Again, guys, please don't get entangled. I know I'm starting to sound like a broken record, but it's very, very important. And I've seen the ugly side of this. So that's why I'm giving you the warning now. Let's talk about compensation. Compensation is a requirement of the N12 notice. So just like the agreement of purchase and sale, a conditional agreement of purchase and sale, there are certain requirements or conditions that must be met. Otherwise, the agreement is null and void. Compensation is a condition of the N12. And if compensation is not paid on or before the termination date, whether or not the tenant moves out, the matter will get dismissed at the board because compensation requirement was not met. So compensation in the amount of 1 month's rent must be paid to the tenant on or before the termination date in the N12. There is also a declaration or affidavit that also must be submitted to the landlord and tenant board. And again, per the new Bill 184, another section of the bill, now landlords must disclose in the declaration or affidavit of any previous notices of termination served to that tenant. So now this is all going to be disclosed to the board. Okay, so please, again, do not serve notices of do not serve any notices, especially the N12. Now, in the previous slide, I said that compensation must be paid whether or not that tenant moves out. You're probably wondering, and one of the questions I'll get asked is, why do we have to pay compensation if the tenant doesn't move out? Remember, it's a condition of the N12. In fact, I highly encourage you to Google the N12 and review it. Read it from front to back, first page and second page. Read it, because on the second page of the N12, the third bolded box from the left down, and here's the screenshot, it tells the tenant, what if you disagree with the notice? And to the right of it, it says, you do not have to move out if you disagree with what the landlord has put in this notice. Okay. Now, what this means is that if the tenant doesn't want to move, or if they don't agree with this notice, they don't have to move. They have the right to occupy the property until a hearing date is held. Okay. Remember, if the tenant doesn't move, it's going to affect your closing date. We're going to talk about the closing date in the coming slides as well. Now, if you have a tenant that decides to leave earlier than the termination date, this is a great problem to have. Then the landlord must return any extra monies that they hold and pay the 1 month's rent compensation. So you're probably thinking, well, yeah, this is great if the tenant leaves earlier. However, I do have agents saying to me, well, if they leave earlier, my client's going to lose 1 month's rent. Well, if they don't leave at all, it's gonna end up costing your client in the long run. Let's talk about canceling the N12. How do we cancel the N12? Remember, once the notice is served, it's served. Okay, there is no way to cancel an N12 notice. Okay, once it's sent, it's sent. That's why landlords should not make decisions on serving the N12 or act on serving the N12 on emotion. Okay, landlords must make certain that whomever is set or included to move in on the N12 is actually 100% committed before serving the N12. Because excuses like, the person changed their mind, or my daughter got accepted to another university, or my daughter got married and now they need a bigger place. None of these excuses are going to fly with the board. And I'll tell you why. The reason why is that none of these excuses negate the fact that the tenant had uprooted their lives, packed up, moved out, more than likely they're paying more in rent than what they were paying this landlord. Only to come, only for the landlord to say, well, circumstances changed. So remember, the board is not going to side with a landlord that comes up with any of these excuses. Let's talk about errors. All legal notices must be free from any and all errors, no matter how minor. If there's an error in the application or the notice with respect to names, dates, the address, you forgot to put basement apartment, you missed the postal code, you missed the city, if there's an issue with the certificate of service, the application will be dismissed and the process must be restarted. Okay, again, this is why I don't want you guys serving these documents. Let's talk about how long it's going to take to get to the board for a hearing date, because only the landlord and tenant board has the legal authority to terminate a tenancy. And when they do that by way of an order, that order must be enforced by the sheriff in order to physically, legally evict the tenant. It's currently going to take probably in and around 4 to 6 months to receive a notice of hearing. Okay, so you're probably thinking, well, if the N12 has a 60-day termination date, if it's going to take 4 to 6 months to get to the board, what's the alternative? Okay, because that's just to receive a notice of hearing to attend the hearing. Okay, who knows how long it's going to take to issue the order? Who knows how long it's going to take if the board is going to give the tenant additional time? This could end up being anywhere from a 6 to 10 month process. So what's the alternative? The alternative is what we call a cash for keys. Okay, let's talk about cash for keys. What is a cash for keys? A cash for keys is basically offering a buyout to the tenant in order to get them to agree to end the tenancy. We do this in the way of drafting an enticing offer and sending it to the tenant. Okay, that enticing offer can be anywhere from 5,000, 10,000. We've seen as high as 70,000, 100,000, 150,000. Guys, I'm not telling you to pay 100,000. I think that's a crazy amount of money. However, the offer must be enticing, and you have to provide the tenant with the tools in order for them to find another property. What are the tools? Okay, so what is going to keep a tenant back from moving? First month's rent, last month's rent, and moving costs. If we provide these tools to the tenant, it's highly likely that they will accept and move on. The legal representative who's going to be facilitating a cash for keys needs to be informed with not only the process, but with the law. They will facilitate a termination of tenancy directly with that tenant. They will negotiate the terms with that tenant. They will draft a consent agreement or a settlement agreement in addition to the N11 mutual agreement to end the tenancy. Remember, this is one of the ways to end the tenancy is by mutual agreement. The settlement terms or consent agreement and the N11 are married to one another. And what that means is that they're signed together and filed with the board together. Once they're filed with the board together, the board will issue an ex parte order. And an ex parte order is just a fancy legal term for an eviction order without a hearing. Okay, so you're bypassing the 6-month delay just to get a notice of hearing. Remember, option number 1 is going to cost you time. Option number 2, which is cash for keys, is going to cost you money. So depending on how the market is in your area or district, you make that money back tenfold, or you should make that money back tenfold. The timing that it'll take to facilitate a cash for keys can be as early as 30 days, 60 or 90 days to even also receive the order from the board. So that if the tenant doesn't leave, okay, if they renege on that offer and they don't leave, even after signing, then we can enforce that offer without having to wait for a hearing. The legal rep will also make arrangements for the keys to be picked up. Guys, like the N12, I also don't want you to be entangled with facilitating a cash for keys. This is what the N12, this is what the N11 looks like, okay? I want you to have a look at this because this is probably the easiest looking form or agreement on in the landlord and tenant board library. However, this statistically, the N11 is where majority of people make the mistakes. Okay, so like the agreement of purchase and sale, it is also an editable document. However, the reason why I don't want you entangled with the N11 is because the tenants have the right to change their minds by bringing forward a motion. And a motion is basically telling the board or the court to do something. And that usually is to put a hold on the eviction if they sign the N11 and they change their mind, or if they get tenant's remorse. The board will then hold a hearing. And if the realtor is involved, this is what I can guarantee you is that the tenant is going to say, I was pressured by the realtor. And the board will then make a decision on whether or not the N11 can be void and the tenant can continue their tenancy, or it can be enforced. So again, the board is not very realtor friendly. So please stay away from terminating tenancy. So the N11 must be completed properly, signed, dated, all the information must be correct. If there are two parties must sign. Any errors, guys, no matter how minor, will result in the board not issuing that order. Instead, they will set a hearing. Okay, so please don't get entangled with serving the N12 or pressuring the tenant to end the tenancy. The consent agreement is, I call it the husband that accompanies the N11. It's recommended that any cash for keys be accompanied by terms of settlement. And terms of settlement is kind of like the rules of the game, okay? What are the terms? When is the termination date? Who holds the funds? When are funds dispersed? All terms in the consent agreement or terms of settlement must be outlined clearly and signed by all parties. Okay, once the consent agreement or terms of settlement are signed by all parties and alongside the N11, they are filed with the board by way of an L3 application. How do we serve legal documents? Let's talk about service. One thing I love about the real estate industry is that the industry has really evolved with technology. And what I mean by that is back in my days, back in 2004, 2005, we were all glued to the fax machine. The fax machine was how we served or how we sent the agreement of purchase and sale to the lawyer, the opposing agent. Fax machines were the only way to serve documents if you weren't hand delivering the documents or dropping them off at the real estate brokerage or cooperating brokerage. The industry has really evolved with the technology. And what I mean by that is that you guys are using your smartphones to scan and sign legal documents. The agreement of purchase and sale is what I'm talking about. You're using your fingers and e-signature tools to just sign and purchase multi-million-dollar properties, right? It's fantastic. You don't even have to meet your clients face-to-face anymore for a signature. It's great. However, the wheels of justice spin very, very slowly. And what I mean by that is that landlords must serve their tenants in accordance to rules of procedure of the board in one of the following ways: by handing the document to the tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through a mail slot, faxing it to the tenant's place of business or residence, courier, registered mail, or express post. Okay, so here's a requirement. If documents are being served via mail, additional days must be added to the termination date. All right, we're coming close to the end of the presentation. I never charge for any of my giveaways. I'm always giving our materials away. If you haven't done so, head over to landlordmastery.ca and download your free Landlord Mastery Guide. So this is a copy of the Landlord Mastery Guide that myself and my husband Rob have put together. If you download this guide, you'll have access to a Google Drive. In that Google Drive, you will have access to scripts, forms, other agreements, notices of entry, how to qualify tenant prospects, what questions you should ask. It's a great guide that you can use in your business, or you can forward the link to your clients. It's a great tool, absolutely free of charge. And here we are at the end of the presentation. Thank you so much. I know it's a lot of overwhelming information. Let's open up the floor for a Q&A. How was that, Lawrence?
That was excellent. Thank you very much, Vita, for all of that. A couple of things I would just like to ask you before. I mean, if anyone has any questions, I guess just put up your hand and then I'll call on you. But otherwise, I just have a few other questions. So what are the penalties for a landlord that illegally evicts somebody?
Illegal eviction. So
Yes.
let's
Both
talk
corporation and personal landlords. What is the penalty?
So for corporations, now let's talk about what is an illegal eviction first. Can we do that? Can we define that?
Sure.
Sometimes we have landlords that are very impatient and they feel that they're going to take the law into their own hands and illegally lock out the tenant, change the locks, or put the tenant's belongings on the front lawn and let the tenant know that they no longer live there anymore. Well, in addition to those fines, and you're looking at up to probably 100,000 for an individual and 250,000 for a corporation. In addition to those fines, okay, the tenant not only can file an application for an illegal lockout and be in front of the board as soon as 3 days from filing that application, they can also be ordered, the landlord can also be ordered to let the tenant back in. And I call that the reverse eviction order, where the tenant takes that order, goes to the sheriff arrives at the property, the tenants can change the locks and provide a key to the landlord, and they will be provided access back to the property. Not only a fine that will be given to them, the board will also order that the landlord pay the tenant any out-of-pocket expenses that the tenant has incurred for the amount of time from the day that they were evicted to the day that they're let back in. That includes accommodation. That includes food if they have receipts. That includes if they have to go buy clothing. That includes if they have to stay at an Airbnb, short-term rental. Guess who that is going to be, who's going to be paying for all of that? The landlord, right? So remember, 3 ways to end the tenancy. N9, tenant's notice, N11, mutual agreement or court order. Do not take it upon yourselves to evict that tenant.
Right. So basically, the landlord will have to pay for all those expenses. But if it's found out that they have illegally evicted them at the end of the day, then I think there's a fine, right?
There's a fine. Now,
how much is that fine?
The fine, off the top of my head, I believe it's 100,000 for up to
100,000.
Up to. I haven't seen that excessive. I mean, I'll tell you, I've seen 10,000, I've seen 20,000, I've seen 25,000. It's all relative. Like if you're illegally locking out a tenant who's renting, I would say, let's say a $25,000 a month of rental property, then yes, I mean, the 100,000 is okay. I can see how it can quickly add up. But if somebody is paying 1,700, then you know, I haven't
not that much.
Yeah.
Okay. So yeah, question
don't be the example. Okay.
Yeah, try not to be the example.
Yeah.
John, did you have a question?
Yeah, thanks for your time.
Hi, John.
Hi, how are you?
Good, good.
Good. I'm in Kingston. I'm wondering, you seem to be more landlord based. Do you do tenant based representation?
We do very few tenants. We're mainly landlord representatives.
All right, because I have a unique situation with actually a friend of mine. She got served notice. Place was listed for sale, sold, and the new purchasers magically have a son that wants to rent the upstairs unit and a daughter that wants to rent the downstairs unit. So I find it kind of, it's a 2-unit place that's for rent. It's grossly undervalued in the rent. So I think it's just a scam to try to get them out.
Has she moved out?
She moves out the 31st of May, unwillingly, like she got served notices, but.
So here's the thing, John, is that bad faith can only be determined after the tenant moves out.
Right. Yeah,
Right?
I understand.
So unfortunately, she's going to have to move out and
Yeah.
see what the landlord does.
Yeah, exactly. I guess the third point is just follow-up investigation as to try to find out who's actually occupying that new, the apartments, right?
Correct. And that's super easy. I mean,
Right.
I have, I had another, I had a landlord who we said that the son is going to be moving in and the tenant had moved out and the landlord was doing some renovations. It took quite a bit of time to do those renovations. And
Yeah.
the tenant actually ordered an Amazon package, right? And and she was really good friends with the neighbor. So she went by to pick up her Amazon package from the neighbor. And I guess through conversation, she found out that the son actually did not move in.
Right.
So, I mean, if your client is close or if your friend is close to the neighbors, it's super simple just to find out.
Yeah, when you say neighbors, you mean the people living like beside, because they're trying to get vacant possession. I think they're going to change it from a duplex to a triplex.
Right.
Right. I think there's some shifty stuff going on there. So
what I would suggest is that she documents everything.
yeah.
Right.
Okay. All right. No, I was just wondering if you did tenant representation. So I was just trying to get you some business.
I appreciate that.
Yeah.
Thank you.
On a side note, then, do you also represent people way outside the GTA or only in the GTA? Like, I don't know how local do you need to be, out of curiosity?
As long as you're in the province of Ontario, we're doing Ontario-wide
Oh,
now,
Ontario. Okay, great.
right? Everything is online and virtual.
Oh, cool. Next question, Meryl, you have a question? Hi, Meryl.
Just trying to
there you go.
I'm there.
Yep.
Hi. Thank you so much for this beautiful session. Really enjoyed it. And I'm actually dealing with this right now. So, so my question to you would be, we are in the process of selling a property. We've listed it for sale and the tenant has barely given us any showing times. And the condition of the property is not all that, but we're cooperating with them with what they're giving us. The building is newer than 2019. So we decided, since we haven't sold it yet and it's coming up to the end of their lease, that at least we take advantage of this opportunity to increase the rent by more than what the government allows. Because it's built after 2019, I guess we're allowed to do that. So we're serving them with an N2. That won't interfere with anything, will it?
Well, it shouldn't, but I think your clients are doing this to squeeze the tenant out because she's restricting showings, correct?
We're not really keen to. I wouldn't necessarily say so because they're taking my advice on this, and I'm the one who's guiding them on this whole process. They're paying 2,600, and the units there now are 3,000.
Okay.
So we just want to take advantage of this rental increase. But of course, if they were willing to move out, I think anywhere they want to move now is 3,000 anyways. But is that something that you would advise?
Well, I can't give advice on here because I'm not retained, right? But
Understood.
the way you're explaining it to me is that what it seems like, because the tenant is not cooperating, is that the landlord is now trying to squeeze the tenant out by increasing the rent. I mean, you can do that, that's fine. The thing is that if the tenant continues to not allow for access, the goal of the landlord is still not going to be met, right? So, I mean, your client may want to consider a cash for keys in order to get the tenant out and then list the property or relist the property. That way they can paint, they can do some repairs, they can stage. The longer that tenant remains in the property, the harder it's going to be, not only to show the property, but Miral, you have to think of, this is not the challenge. Showing is not the challenge. The challenge is getting an agreement of purchase and sale and providing vacant possession. If you're experiencing issues, now pay attention to the red flags now. If you're experiencing difficulties with the tenant now, how are you going to get the tenant to move out? If the tenant doesn't move out even after an N12 is served, which they're not entitled to move out, your client is now going to be in breach of contract of the agreement of purchase and sale. And now they're going to have to start paying a penalty to the new purchaser up until they are able to get that tenant out.
Okay,
Does that
so
make sense?
yeah, but my understanding was that once you've sold the property, if I'm careful of maybe potentially crossing out that line in there that says vacant possession and getting my client to initial it, is that possible?
Well, again, I can't give you legal advice on that. You're going to have to contact your real estate lawyer. But your clients, I think the best suggestion to give your clients is that they need to seek legal advice on this tenant. So feel free to contact me later on or have them contact their real estate lawyer. But they need to have a plan on how to move forward. Just guessing on how to move forward is going to put them in a very difficult position.
Okay, understood.
Okay.
Thank you so much.
You're welcome.
In terms of suggestion, I mean, for the actual showing part, I have found that to be a pain in the past. You really do want to try to get rid of the tenant. If you can't, alternatives would be to sort of bribe them to leave during showing, try to have like an open house during like a 2-hour period and just tell everyone to come during that time. That helps sometimes. But again, the main issue is down the road. You still need to provide vacant possession and they have to leave. And so if they don't leave, like you're going to be in a worse position, as Bita can tell you. So Bita, what's the worst that someone has been, we won't say extorted, but we'll say squeezed significantly by the tenant? What's the most, because basically, if you don't provide vacant possession, all of a sudden you're going to get sued or whatever it is, or I don't know exactly what mechanisms they have, but there's a lot of issues. And so what is the most that someone has been squeezed for, a landlord?
Okay, so we had an offer. Now, let me talk about illegal extortion first, okay?
Legal extortion.
So it's not extortion, okay? And I'll tell you why. It's a settlement, okay? Extortion is to force someone to pay or to do something,
Right.
okay? You're not, the tenant is not forcing the landlord to do anything.
Yeah, the landlord will just lose a lot of money if they don't do it, but yes, they're not forcing them.
Well, remember, Lawrence, the tenant has rights under the act.
They have the right to stay there.
They have the right to remain. So if the landlord wants them to do something, they're going to have to pay. The highest we've done is 150,000.
150,000.
Yes, and here's the kicker, Lawrence. The tenant refused 150,000.
Oh my gosh.
Right, but generally, in and around 7 to 10,000, it works with the cash for keys. 7 to 10 is reasonable. But again, you asked for the highest, I gave you the highest.
150,000 and they still said no.
And she still said no.
Wow. Okay. I have another question here, which we did cover before, but basically if the seller is a corporation and as a firm APS, you can't issue an N12. Can you please reiterate that?
Right. So if the seller is a corporation, 1234 Ontario Inc., and they want their child or parent, or they want to move in, the N12, they cannot serve an N12 because a corporation cannot legally occupy the property.
Right. A corporation is not a person, so the corporation does not have kids and does not have parents.
Correct.
Similarly, if a buyer does the same thing, a buyer corporation cannot issue.
Correct.
Right.
They're going to have to amend that agreement of purchase and sale and purchase the property personally.
Right. Okay. And then if you are selling it and you want them to assume it, then I guess you just have a clause saying that the purchaser will be assuming the tenant.
Correct.
Okay.
Correct.
Okay, that answers that question. Anyone else have anything else? 12. Someone put their hand. Whose hand is that? Trisha, can you please ask your question?
Hi there. Oh my God, this is such a great session. I have a client I'm working with. They are living in a townhouse and it's been sold. The landlord told them they have to be out in 9 days, but it doesn't actually close until June 28th. So I told them, you know, we've got time to look for something else. But if she wants to stay there, what do they file at the board? Like, do they just go and tell them the situation, or is there a form that they can fill out? You know, if they want to get in front of the board for a meeting, or how does that work?
Are you saying that the landlord wants to get in front of the board?
No, the tenants. I'm working with the tenants to find them another place because she said they've been given paperwork. I just met with them yesterday via Zoom, so I haven't seen the actual paperwork that the landlord has given them. So I don't know if it's legit or, and he's
Right.
also a realtor, the landlord. So
Okay, oh boy. So if no N12 is served, then the tenant shouldn't be moving.
okay, but
Okay.
what do they
That's the
do?
board.
If they have got an N12, is there a form they file with the board to say they want to stay?
No, they just stay. And the landlord would have to file with the board to get them out. But before the board can order an eviction order, they're gonna hold a hearing.
So the landlord just, or sorry, the tenant stays put, they don't have to do anything at all.
Correct.
So they
just
don't go
have
to the
pay their
board.
rent like they normally do.
Okay, so they don't go to the board and say, my landlord is sold, he wants to evict us.
No.
What do I, like, they don't do anything.
They don't do anything. Just continue to pay your rent in full and on time. And it is the landlord. Remember, the agreement of purchase and sale has nothing to do with the tenancy. Right? So just
Right.
because the property is sold does not mean that the tenants have to move. The seller landlord has an agreement of purchase and sale with the buyer, and they have a lease with the tenants. There is no relationship between the buyer and the tenant.
Okay, great. Thank you so much. I also have a tenant townhouse coming up. I'm going to represent the seller, so I'm going to have them contact you.
I appreciate that, Trish.
I don't want to get sued.
Smart woman.
Yeah, it's a good idea. Just try not to get sued, because at the end of the day, if the landlord does get a fine or does get, you know,
Yeah.
lose some money, like they're gonna want to blame somebody, right? So
Yes.
you're the easy person. If you're the one who filled out the piece of paper and you're the one who tried to serve it, then it's your fault. But if you're not even involved at all, like how, like what are they suing you for, right? Nothing.
Exactly. I have a 6'3", 16-year-old. I can't afford to pay money for anything.
Oh,
Thank you
boy.
so much.
You're welcome.
No problem. And while we're on the other question, so this is just random, not really about evictions, but a lot of people about the max rent increase after what 2018 or whatever it is. With that, I've heard different things about that. I think the ruling is what, that it's just got to be reasonable, but there's no actual decision on what that is.
And are you saying 20? What was that? 20?
Basically, where they remove the rent cap, the rent control for newly rented properties after whatever the date was. I think it was
November 2018, right?
2018. Yeah, after November
Yeah.
2018. And so some people are like, oh, great, I can like double the rent. And I'm like, I'm pretty sure you can't do that.
There's no cap.
But is there any ruling on how much you can increase? So like now you owe me $1 million a month?
Well, it has to be reasonable.
Right. So like the question I guess was what have they
What
made a
is
ruling on
reasonable?
what reasonable is?
I don't have an answer for you.
Okay.
What is reasonable is the tenant not paying
Yeah.
and not paying the rent increase. Always pay your rent. Okay. If you want to challenge the increase, you can challenge the increase at the board. Okay,
it.
so it's going to really be, you're going to be rolling the dice at the board. But that's why I said, I think it was to Morale, is that you have to really be careful on the scenario and what's going on, and then increasing the rent, because the way it looks is that I can't get you out because you're trying to hold the property hostage.
Yeah.
I'm just going to increase your rent.
Yeah. So
And
like $5 million a month, and you're like,
Right.
okay, I guess I can't pay that. I guess I'll leave, right?
Yes, I have to leave, right? But then ultimately it'll come down to what the board says
Okay.
if it
Makes
gets
sense.
challenged.
And back to Trisha's question, the idea of the tenant is it's really until you get like a piece of paper, like you're just living there, right? So when when
Sure.
the landlord is like, so I'm about to sell the place, like, that's nice, you know, so you should probably look for another place, like, yeah, okay, that's nice, right? Like it doesn't matter until I actually force your hand by giving you a piece of paper and not just like
Right.
suggestions.
I mean, just like you said, you just said it. The N12 is just a piece of paper. It's just a notice, right? And I can't tell you, Lawrence, how many agents I have that say, well, they have to move. Well, no, they don't, because there's no enforcement of that notice until you go to the board. And the challenge is, by the time you go to the board, you've probably missed the market to get top dollar.
Mhm.
That's why landlords often end up doing a cash for keys before listing a property, so that the tenant is out in 30 days. And then they're still in time for the market. And they'll make that on the sale.
I think so. I mean, even the idea of just cleaning it up, repairing, staging it, like it looks so much better. You know,
That's
you're
right.
gonna get a top dollar for that, in my
That's
opinion,
right.
versus just having, you know, I've dealt with trying to sell things with tenants, and it's just they don't let people in. They're sleeping in on the weekend. It smells like smoke and like dog everywhere. It's like you're not selling that for top dollar, you know.
And you can guarantee vacant possession.
And you can guarantee vacant
Right.
possession. Yeah, that's true. One, if they do sign like if you get the N12 or even the N11 and it's like a certain date, let's just say 3 months in the future, and they move out earlier, does that mean that they're still sort of legally entitled up to that date, or like
If
if
the
they moved
N12
everything out?
Well, they're legally entitled to that date, but in the N12, it says if the tenant moves out earlier, they can issue an N9 within 10 days.
Oh, okay. So there's an N9 after the
correct.
N12 if it's vacant. But for the N11, let's just say, you know, N11, we say like 2 months ahead in the future, but then they decide to move out 1 month later. We can't do anything until the 2 months from now, like the date of the N11.
Or you can revise the N11 and do a new one, bringing up the date
Yeah, if they sign it. I
if they
guess.
sign in.
If they sign it, and if they
I mean,
don't, then you.
if they don't, then they have to pay the rent. They can't just leave the property vacant,
Oh yeah, okay. So
right?
there's
So
some mechanisms there.
there you go.
Great. Anyone else have any questions while I just think of other stuff to ask? But otherwise, I think it's about an hour, so that's probably pretty good. Last chance. All right. Well, thank you very much, Vita. Really
Yeah.
appreciate the talk. It's been super informative. I'm sure a lot of realtors learned a lot of things today. And the main thing is just don't serve any notices and don't get involved.
That's
Like, just
right.
don't get involved.
Do what you do best, and that's selling the property.
Yeah. And then, and if you have any questions, just talk with Vita from Stonegate Legal Services. So what's the best way to reach you?
The best way is always email info@stonegatelegalservices.ca.
Mhm.
If you call the office, feel free to. Often I'm either in hearings, negotiating with tenants to terminate tenancy, or on trainings. So setting up phone calls, it'll take me a day or so to get back to you. But if you do call the office, any one of our powerhouse legal team representatives are here to help you.
Awesome. Sound great. Well, thank you very much. Again, I'm Lawrence
you.
Mack, real estate broker out of Mississauga in Toronto, and that was Vita from Stonegate Legal Services.
You guys
Thanks,
are
everyone.
awesome. Thank you.
Thank you, everybody.